The opposition INDIA bloc picked former Supreme Court Judge B. Sudershan Reddy as its vice presidential nomination. Within hours, Union Home Minister Amit Shah said Reddy had supported Naxalism because of his 2011 Salwa Judum judgment. Now, the Salwa Judum judgment has its genesis in the Salwa Judum movement, which is a unique tribal peasant movement that arose against the specific agenda of the Communist Party of India, Maoist, in its full intensity in 2005 in the sub-region of Bastar. It was unique because the movement targeted Maoists, unlike earlier peasant movements in rural India, which were usually against the states or the landlords. Now, it grew out of decades of tribal anger against the Naxalites. However, on July 5, 2011, Justice B. Sudershan Reddy's bench shut down the Salwa Judum in Nandini Sundar and others versus State of Chhattisgarh by declaring the use of tribal youth as special police officers unconstitutional. Now, the youths who were themselves up in arms against the Naxals were disbanded. This meant the state lost thousands of on-ground fighters familiar with Bastar's terrain at the peak of Naxal operations. Though there are aspects to the judgment highlighting constitutional tenets such as Article 21, the implication of the judgment was that it weakened the state's counter-insurgency architecture. A classic case of judicial activism colliding with national security. When Justice Reddy banned this movement and called such groups illegal, it effectively took away one of the state's sharpest weapons against the Maoists. Anyway, ये तो हो गई सालवा जूडम जजमेंट और अमित शाह with loggerheads at the opposition's VP nominee की बात. With VP's elections upcoming on September 9, देखते हैं what comes out of this. लेकिन Mr. Home Minister's statement has definitely stirred this issue of retired judges activism also. It would be a travesty अगर हम कुछ ऐसे judges की बात ना करें who after retirement have stopped being neutral arbiters of law and turned into self-styled champions of civil liberties. For example, Justice Madan B. Lokur. In the NJAC case, Justice Lokur wrote a conquering opinion. His stand was that the collegium system, or simply the practice of judges appointing judges, not envisaged in the constitution by the way, should continue. Now, his stand continues to push for constitutional morality and more transparency in judicial appointments. Exactly how will transparency be maintained in a system which is opaque and free from any institutional accountability? No word on that, no solutions for that. Next, Justice S. Muralidhar is another person who has been very vocal with civil liberties per se. Yet, the consistency and tone of his post-retirement advocacy naturally raises some questions about where a judge ends and an activist begins. Now, after he retired, he has also been very vocal about press liberties. The judge had, during his tenure, set aside an order granting transit remand of Gautam Navlakha, an accused in the Bhima Koregaon violence cases, basis procedural irregularities, effectively just freeing him. Now, he faced a lot of criticism for this order, with S. Gurumurthy writing against this, calling him out for supporting his wife Usha Ramanathan's ideology. In return, the Delhi High Court slapped a contempt case against Gurumurthy. Sorry, did someone say champion of civil liberties? There's no denying that the caliber of these jurists is definitely there. But the scale of the post-retirement activism, which is now seen a lot, raises a structural question. When judges trade robes for op-eds, are they enriching public discourse or skewing it? For a healthy democracy, we need both principled voices and a space for neutral adjudication. The debate isn't about silencing them, but ensuring their continued influence is balanced, transparent, and rooted in constitutional integrity, not hypocrisy.